Welcome to the first day of our GDPR 5-day challenge. It's great to have you all along as part of the challenge. And whether you're watching this now at 8 o'clock or whether you're watching it a bit later in the day, welcome to the challenge. And talk to you quickly through what we're going to do over the next 5 days. And as you know, it's going to be about 30 minutes every day for this. Then there will be something for you to do during the day, which again, I don't want you to spend more than 30-45 minutes on. Don't want to take up hours of your day. And then we'll be having a session at 4 o'clock every day, for which I'll send you out the Zoom link later. It'll be a Zoom session. It'll be totally live. You can come on there, ask me any questions about either something we've done that day or once we've covered questions for the day. If you've got any other general GDPR questions, within, again, about 30 minutes, then we can cover those off too, hopefully. And we got an extra bonus session on Friday, but I'll tell you about that when we get nearer to Friday. So what we're going to be covering over these next 5 days then, well, today is very much just going to be an introduction to GDPR. Tomorrow, Tuesday, we're going to talk about data subject rights. Wednesday, we're going to talk about data breaches and how you handle them and security measures to hopefully stop them happening in the first place. Day 4, we're going to talk about DPIAs and privacy by design. And then day 5, we're going to round it off talking about compliance and accountability. Now, unfortunately, in 30-minute slots, there's not time for me to cover absolutely everything that would normally do in a full GDPR training course. But hopefully it will give you enough to let you realise what you need or should be doing, and also to let you know a bit about what we do, and hopefully some of you might want to carry on working with us in the future. But anyway, for today, introduction to GDPR. So I'm going to begin with a history of GDPR. And all this really started way back in 1995 with the EU Data Protection Directive 95/46/EC, if you really want to look it up. And that was the first time really that the EU had tried to bring in some rules around data protection to protect data of the individual right across the EU. And so in 1998, the UK, as our part of that, adopted that, and we adopted that by bringing in the 1998 Data Protection Act. However, every other country did the same thing. So we ended up with lots and lots of different data protection acts right across the EU. Everybody had slightly different things in their data protection rules and regulations. Some were much stronger, some were much weaker, some had nothing at all. And it really was a bit of a hodgepodge. So in 2014, which when I first started to become aware of GDPR, there was a drive for a common data protection standard all the way across the EU, right across every country in the EU. And at the time, and I can still remember being part of the discussions way back in 2014, everybody thought, wow, by December 2015, we'll have everything in place, won't we? As you know, that didn't quite happen, and as often happens when you get governments of whatever colour and whatever creed right across the EU, things take much, much longer to sort out than you think they will. But in 2014, there was a drive for a common standard, and in 2016, the EU adopted the General Data Protection Regulations, or GDPR, as it's known. And the important thing just to say is right across Europe, although the words change, because obviously in different languages they don't say General Data Protection Regulations, the acronym is always GDPR. Now for us it's nice in English because the acronym makes sense with the initials of each word, but in other languages it doesn't quite make the same sense. But as I say, it's still called GDPR, so everybody knows what we're talking about. Again, it was thought that that could be brought in quite quickly. In fact, it didn't become mandatory until the 21st of May 2018, when GDPR came into force across the EU, and here in the UK it was adopted into the 2018 Data Protection Act. And by the way, something the ICO always looks for to see whether companies are compliant or not, and an easy clue for them that maybe you're not is if in your privacy policy, and we'll come on to privacy policies much later in the week, but if in your privacy policy you mention that you're in compliant with the 1998 Data Protection Act, that raises a little bit of a red flag. So if you do nothing else today, have a quick look at your privacy policy. Make sure it says that you're abiding by the 2018 Data Protection Act. So we did all that. 25th of May 2018, GDPR came in force across the EU. Wonderful. Suddenly everybody had a common set of standards that we were working to. But then, and this will be good news for some and not so good news for others, but hey, it's happened. You remember that in 2020 we had Brexit. Brexit meant that now we needed our own GDPR, which became known as UK GDPR, and indeed that's what we work to today. GDPR, UK GDPR is 99% the same as EU GDPR. I'm not going to cover the differences now. They are very technical, but nothing that actually changes how things have to be done. However, the EDPB, the European Data Protection Board, has this thing of declaring whether countries are adequate or not. And if you're an adequate country, then you can transfer data easily with other countries that are considered adequate. So obviously every country in the EU is considered adequate, and there are a number of external countries that are considered adequate. And it almost went right to the line because it had been decided that we were going to leave EU GDPR on the 31st of December 2020. It was actually the 1st of January 2021, but because Europe's an hour ahead of us, for us, it was the 31st of December still, 2020. And only a couple of days before that date did the EU finally declare they were 100% happy with UK GDPR and declared us to be an adequate country, which was a big relief to everybody. And so UK GDPR is what we are currently working with. Now, the previous government, prior to the general election in July, the Conservative government, were passing a data bill which would have made some changes to things. They wanted to make the whole thing with GDPR a bit lighter touch in the UK, I think it's fair to say. And GDPR practitioners like myself were a little bit worried, well, in fact, more than a little bit worried, that might mean that the EDPB would suddenly declare that we weren't adequate anymore. And that could have given major change problems for business, really, because suddenly pretty well any business sending data to Europe would have needed to rewrite all their contracts and everything, which is just a pain. So, but with the calling of the general election in July, the data protection bill that was making its way through Parliament got guillotined, which means essentially it dies, it's gone, doesn't exist anymore. Now, the new Labour government does have their own ideas for a data protection bill, for a data protection and digital information bill, which they've already laid the first steps of before Parliament. The good news is, well, good news for people like me, and I think it's good news for business as a whole, is that they're not really proposing any changes of substance to UK GDPR. And so I think that's good news. It means we can not relax because we have to be compliant with what's there, but at least we know what we're working with. So that hopefully gives you a bit of a background of the history of GDPR. So the next thing I want to talk about is a GDPR who's who, because you'll hear different terms for people and companies mentioned in the whole GDPR process. So who are they and what does it mean? So the first is, who is a data subject? basically, if you're in the UK and you're alive, you have a pulse, from the moment you're born to the moment you die, you're a data subject under GDPR, UK GDPR. Important point to us is the moment you die, you actually stop ceasing being a data subject. And so all rules GDPR about privacy don't apply anymore. There might be other laws that apply, but GDPR does not apply to your data anymore once you are dead. But all of us are living. Obviously, I'm living. Hopefully, everyone watching is living. And therefore, we are all, assuming we're in the UK, we are all UK GDPR data subjects. If we're in the EU, we're an EU GDPR data subject. But we're all data subjects. Every data subject has data about them, of course. How is that controlled? It can be controlled in two ways, really. One is, the main thing is you are a data controller. Now, your business is probably a data controller. Even if it's just a one-man business, it's probably still a data controller, because if you hold details about your clients, personal details about your clients, or you hold details about your staff, or you hold details about your suppliers, and it's personal information, then you're a data controller. That matters not whether you hold it on a computer or whether you hold it on paper, doesn't matter. You're still a data controller, providing you hold that information in a structured filing system. And this is where things like business cards become a bit of an anomaly, because if you've got business cards and they've got people's personal information on them, if you keep them in a Rolodex or some such similar system, or card filing box, they fall under GDPR. If you just got them randomly scattered in the bottom of your drawer, they don't. Quirk of the regulations, but there you go. So it applies if you've got data in a structured filing system, and you can decide what happens to that data. You can amend that data, you can delete somebody, you can add somebody new. You're data controller. However, the other term you'll hear put about is data processors. So who is a data processor? Data processor is someone who processes data under the instructions of a data controller. So a typical example will be your accountant. Your accountant's probably processing personal data because you're asking them to, particularly if you've got payroll. If you've got payroll and you've got an accountant or you've got a payroll bureau doing your payroll for you, then that payroll bureau is a data processor. Likewise, if you process orders for somebody and you've got a company who's handling the fulfillment of those orders for you, then the company handling the fulfillment is a data processor. What's the crucial difference? The data processor can only do to the data what you tell them they can do. And for that, between each data controller and each data processor, there must be a data processing agreement, something called a DPA. Now, that can sometimes be a very lengthy document. It can sometimes be fit on easily on half a sheet of A4 paper. Really doesn't matter. What matters is there is an agreement. There's a data processing agreement between you that says, I'm the data controller, I'm letting you do this to my data, and if this happens or this happens, then I want to know. And if this happens or this happens, you've got to give me the data back, or you've got to destroy it, say the. But that's the essential difference. You will sometimes come across the situation as well, though, where someone's doing some work for you, but because of the amount of things you let them do to the data, they're effectively just another you. That actually you can be joint data controllers. Sometimes it's not the case. You have a data controller and a data processor. It might be you have joint data controllers. Either way, though, whatever that arrangement is, you still need to have a data processing agreement, a DPA. And if you're not sure if you've got them in place, then do arrange a one-to-one with me, have a chat with me, and let's talk through it and see what we can do. Or, of course, you can ask me if you feel comfortable. You can ask me about it in one of our 30-minute afternoon sessions any day this week. So, hopefully that's covered some of the terminology of data subjects, data controllers, data processors, and we've actually mentioned DPAs, those are data processing agreements. So let's talk a bit about some principles of GDPR. What are the key principles behind it? First one is lawfulness, fairness, and transparency. So you can only handle somebody's data if you have a lawful reason for doing so, and we'll come on to that in a second. But you also have to be fair in the way that you handle their data. And you also have to be transparent. So you have to be able to say to somebody, yeah, we take your data and this is what we do with it, or this is why we hold it, or this is how long we keep it. They're all things that you have to be transparent about to the data subject. So what are these lawful reasons then? Everyone thinks about consent. It's talked to most people about, can we handle somebody's data? Oh yeah, we need their consent. Well, no, you don't, actually, most of the time. If you're marketing to them, you most definitely need their consent. Unless it's just business to business marketing. And then you actually don't need their consent. You can, if you're sending an email to a business email address, fill your boots. You can do it as much as you want. I mean, I wouldn't overdo it because you'll pee them off and they'll never do business with you anyway. But you don't have to worry about GDPR as far as concerned with business email addresses per se. But be careful, because some people use Gmail for their business email. Some people use Outlook, etc., etc. And those do fall under GDPR because they're considered to be personal email addresses. So you need consent if you're going to market to them, really. But reasons you don't need consent is if you have a contract with somebody. If somebody's already bought from you, then it's expected that you're going to send them things. And so you've got a contract with them. You don't need their consent as well. Just having the contract is enough. Likewise, if you've got employees, you have an employment contract with them, you don't need their consent. You've already got a contract with them. You don't need consent to hold somebody's information if the law says you have to. Again, payroll is probably a good example, but other examples might be that you need to keep copies of invoices. So if the law says you have to keep somebody's information, then you don't need consent to hold that information because the law says you have to have it. A vital interest is a bit more of a interesting one, really. The vital interest is where it's in the, you can argue that it's in the interest of that data subject that you hold that information. Now, on the whole, apart from medical information, that's quite a hard one to actually prove or satisfy. But medical information certainly comes in that. If you've got employees and one of them's diabetic, then actually it's well worth you recording that that person is diabetic, because then if they do happen to collapse at work and you have to call an ambulance for them, it's really, really useful to that ambulance crew to be able to tell them that the person's diabetic. So things like that fall under vital interest. Public tasks, unless you are a local authority or you're a government quango, you can't argue that you're holding data under public tasks. And I don't think, from memory, anyone who's registered for this challenge is in either of those situations. So I won't dwell on public tasks except to say it's really there for government business, whether that's local government or national government. But then the final one is legitimate interest, and this is the one that most of the time will be the reason you're holding somebody's data if you're holding it without consent. And what this is it uses something called the balancing test. And the balancing test says, is the risk of me holding that data to the individual higher or lower than the risk to my business if I didn't hold that information? And providing that you come down the right side of that balancing test, providing that the risk to the individual is far less than the benefit to your organisation. Again, it's a bit of a perception thing, so don't worry if you don't quite understand that when I first said it. We can deal with that in more depth. But providing you satisfy that test, you can say we're holding this information because it's in our legitimate interest to hold it. Okay, so you also have to think now about purpose limitation. What does that mean? It means that you can only use the data for purposes that you've defined that you're going to use the data for. So if you said that we're only going to use that data for marketing, you can't suddenly use it for something else. If you said you're only going to use that data to fulfill somebody's order, you can't then use it for marketing unless you've got consent for marketing. So it's very important that you consider the purposes for which you're holding data, and you don't suddenly think, oh, I've got this chunk of data over here. Yeah, I collected that last year for that thing we were doing. That's okay. I'll use it again this year. No, it isn't. Don't do that, please. It is about purpose limitation. Again, if you're unsure, then let's have a chat about it. Next is data minimization. You've got to hold a minimum amount of data that you actually need to do whatever it is you say you're doing with it. Now, most of us do that naturally anyway, but it is surprising, particularly if you've got a CRM, a customer relationship management system, or you're holding the data even on a spreadsheet, but performing the same purpose as a CRM, that we learn extra things about people and we record them and we record, right, oh yeah, he likes playing golf because that's something he does. Can we justify we need that for a legitimate reason for our business? Not quite so sure. So just be careful that you minimize data and hold the minimum amount of data about a data subject that you actually need to hold to fulfill whatever it is you're doing for them. And one which is coming far more to the fore than it used to is data accuracy. If I've got your contact details in my phone and I've known you for more than 3 years, there's a good chance that some of that contact information is no longer accurate. So really, I should be checking with you that it is still accurate. So good practice these days, and you've probably noticed other companies doing this to you, is if you've got a client on the phone and you're talking about things and you say, oh, can I just check? I've still got the right phone number for you, still got the right delivery address, Because it's actually a requirement of GDPR that you do that, and it's actually good business practice to do that anyway. Because if you've got the wrong delivery address and you send that person ordered something and you send it to the wrong address because you haven't bothered updating your data, you're now an unhappy customer. And you don't want that. We all want happy customers. So do make sure that your data is accurate and up to date. Storage limitations is all about where do you store data, how do you keep it safe, and how long do you keep it for? Each item of data that you hold, and by that I mean, a client record, a customer record, an employee record, a supplier record, you should have a policy somewhere that defines how long you keep each of those types of data for. You have a data retention policy, as it's called. And you should have that for each piece of data so that you can say, yeah, we keep that for X number of years after you stop being a customer, or we keep that for X number of years anyway, or whatever. But most people, it's going to be a relatively low number of years, but there can be exceptions. I deal with a championship football club as one of my clients, and they made a decision, particularly for their player data, that they would keep it for 100 years. Because A, there's contractual reasons why they do that, and B, also there's public interest reasons because, they might have someone who contacts them who said, can you tell me, so-and-so and so-and-so who scored the winning goal in the 1958 Cup final, tell me some pieces of information about them. So, they have a valid reason for holding it that long, but most people don't. The other thing is integrity and confidentiality is making sure that you hold data and you keep it confidential, keep it safe. And as I say, important thing is that these rules apply to all personal data, however it is stored. Whether it's on paper, whether it's on a computer, however it's stored, if it's in a structured filing system, GDPR applies to it. And under GDPR, individuals have certain rights. They have the right to be informed, so they have the right to ask you what you're doing with their data. They have the right of access, so they have the right to see all the data that you hold about them. They have the right to rectification, so if there's errors in the data, they have the right to ask that you put it right. They have the right to erasure, so they can ask you to delete their data. They can request you delete their data. They can't actually insist that you delete it, because you might go back and say, actually, under one of the other criteria, there's a bad reason why we need to keep your data. But they can request you to delete it. But what they can definitely do is they can ask you to restrict processing, so you no longer email them, for example. They have the right to data portability, so this often occurs with employees, that they ask to have, can they have all their payroll data, and then they have it transferred to their new company that they go into, or their new organisation they go into, and they have the right to that under GDPR. And they have the right to object to you doing something to their data, or to you holding their data at all, actually, if they feel strongly enough and they've got a case. And then they have rights to go on automated profiling or decision making. So if you do any automated profiling on your data that you hold about people, then people have the right to say they don't want you to do that. They want to do it manually. I've got one client with one employee who insists that their payroll is worked out manually because he doesn't trust automated ways of calculating payroll. It's a big pain for that client, but that employee is perfectly entitled to do that. So that's been today's introduction. That's it for today. But before I let you go, I've got your task for you to do before tomorrow. And I want you to do some data processing mapping. What does that mean? Just get a sheet of paper, draw out what data you process. So like client data, supplier data, employee data. What data do you process? And why do you process it? I say, just spend about half an hour thinking about that today. I don't want you to take too long thinking about it. But if you can do that just on one sheet of A4, please don't do more than that. Just want you to have a very outline think about it, because that will help later in the week. And if you have any questions, you know that's me. My contact details are there. They've also been an email that you've received. And please either email me if you have an urgent question. Otherwise, remember that we'll be back on Zoom at 4 o'clock this afternoon. And please use the details that are in the email that I will send you later today to join me there. And I look forward to seeing you there and to answering any questions you have about what we've covered today. And if you're not coming to that this afternoon, then I look forward to seeing you again tomorrow. And with that, thank you very much for watching this video, and have a good day.